Hi guys, good morning. So I think we start now. Can you guys see the screen? I share the questions. I think you guys can see, right? Okay, so I will start with question one. So you guys have any questions, then you can write in the chat box, then I will reply accordingly. Okay, so number one questions. Um, On 26 May 2023, OKT was arrested by the police, and the next day, he was charged for self-administration of a dangerous drug under Section 15, Sub 1, Sub A of the Dangerous Drug Act 1952, which was punishable under Section 39C, Sub 1 of the same Act. Section 39C, Sub 1 provides that if a person is found guilty of an offence under Section 15, Sub 1, Sub A, he shall be punished with the imprisonment for a term which shall not be less than 5 years, but shall be exceed 7 years. And he shall also be punished with whipping of not more than 3 strokes. The prosecution was conducted by Inspector P.O. After the charge was read and explained to OKT, he pleaded guilty to the charge and was convicted and sentenced to 5 years imprisonment and 1 stroke of rantat. OKT was not represented. Okay, for this question, I think first thing I want to highlight is that actually, according to Section 15, Sub 1, Sub A, the punishment actually is not Section 39C, because pursuant to Section 15, the punishment actually is, I show you the sections, is only a fine not existing 5,000 or imprisonment not existing 2 years. However, the question also, they give you Section 39C. Actually, Section 39C is where you have previous conviction for the same offense, which means you've been arrested for more than at least one time. You have prior admission or conviction, which means this is not the first time you was arrested for self-administration of drug. Okay, so if we back to the question, actually, when they say the punishment is under Section 39C, is not correct, because pursuant to Section 15, by right, the punishment should be just 5,000 or 2 years. The reason I highlight it is because later the question will ask whether we can get a bill or not. As you guys know, by right, for DDA, we shouldn't get bill because this is unbearable offense. Okay, but then there's still a exceptions that if the punishment is below 5 years, you can still ask the PP consent to get the what we call bill. So that's why I don't know the examiner intention why they give you Section 15, but then they tell you, oh, the punishment actually is more than 5 years. Okay, so you see, the question number one is whether OKT has the right to be granted bail if he pleaded not guilty. So like I mentioned, we have 3 types of bail: bailable, non-bailable, and unbailable. So for bailable, just a moment, I miss a student. Okay, can you guys see my screen? I am showing you, okay, we have 3 types, which is bailable, non-bailable, unbailable. So I just quickly tell you what is that. Bailable means like those offense mentioned in our CPC, the first schedule, the CPC, they say it's bailable. That means whenever the offense is bailable, then you can straight away ask the police or the court give you bail while doing investigation or pending charge in the court. Then non-bailable means the court has discretion. So on our facts, CP's DDA is an unbailable offense, and if the imprisonment is less than 5 years, we can still ask for bail if PP certified. So when we back to the questions, if they tell you under Section 39C, the punishment is not less than 5 years, then actually pursuant to Section 39C, we cannot get any bill at all for unbailable offense. But then if you didn't follow Section 39C, you just follow Section 15, like I show you the sections, it's only not more than 2 years. So by right, we should be able to get the bill. Okay?
Sure.
Wait, I mute a student. Okay, so I think my answer for this question will be yes, we can still ask for bill if pursuant to section 15, if we don't refer to section 39C. So PP certified must obtain, a certificate must obtain. So pursuant to section 15 sub 1 sub A DDA, the punishment for this section is a fine, not exceeding 5,000 or imprisonment for terms of not exceeding 2 years. Furthermore, pursuant to section 41B, where the offence is punishable with imprisonment for 5 years or less, the bill can be granted only if PP certified in writing and there is not for public interest to grant the bill to the accused person. Okay, so this is I don't know the intention of the examiner lah, why they ask you section 15 but then they mislead you by giving section 39C to you lah. Okay, if I think you continue to write section 39C, you cannot, the answer will be no, cannot get the bill, then that's it. I don't think it's a answer for 5 marks. Okay, then next one, which court would have jurisdiction to hear the case? So like I show you the section, it's only 5,000 and not more than 2 years. So if fine only and also not more than 2 years, this is very low, right? So it should be magistrate court law, because I believe all of you should have known already lah. Magistrate court is triable jurisdiction, 5 years. Then section court is everything except death penalty. Then high court is all kind of offense, include death penalty. Of course, the highly examinable will be magistrate court lah, because they like to ask you, sorry, for magistrate court is 10 years, not 5 years, but sentencing jurisdiction is 5 years. So the highly examinable area will be magistrate court law, because section court and high court can trial everything so nothing much to ask So usually they will focus on magistrate court law. So you guys should remember to study and remember some case law for magistrate court. So for this one will be magistrate court as well. So for my suggested answer, you can refer to my Facebook lah. Okay. Then I continue. Okay, whether Inspector PO has authority to conduct the prosecutions. Okay, so again, I will assume everybody will have some preliminary understanding, but I will still repeat a bit. But if any of you don't understand or need explanation, please just let me know. So for powers to do the criminal prosecutions, we know all power is with the public prosecutor. So the three main power will be to institute, to conduct, and to withdraw. So all these powers should be with the public prosecutor. But the question asked you is whether inspector can have this power to conduct or not.
If he was alive, all right, so that's important. And then, of course, it must be caused by the direct or indirect negligence of the defendant. Okay, you can.
Okay, so of course, generally it cannot lah. Like I say, these three powers should be with prosecution. So is there any exception to say other than prosecution, the other people also can conduct the what we call prosecutions? So I will share the sections will be section 377. So every criminal prosecution before any court and every inquiry before magistrate shall be conducted by PP. However, by virtue of section 377 sub B sub 2, an inspector may conduct a criminal prosecution subject to control, direction, and written authorization of the PP. Okay, so this is the exceptions lah. Of course, in section 377, there is a list other people also can do lah. Like for example, lawyer or government servant, they also can conduct the prosecution as long as you have the authorized letter from the PP. So I think this question is pretty straightforward. Then D, whether it was safe to accept OKT QT plea. Okay, I think 10 marks. So of course you need to write some general rules. I think I shared before. For 1 to 5 marks, your answer should be like half a page. Then 5 to 10 marks will be like one full page. And then 10 to 15 marks will be 1 page and half. And then 20 marks will be, I think, better 1 page and half and also 2 pages. So for this kind of question, it's 10 marks. So of course, you need to explain some general rules for the accepting of the guilty plea. So the relevant section will be section 173B. Okay, this one. If the accused plead guilty, the plea shall be recorded and he may be convicted. But the precondition is that the court must make sure the accused understand the nature and consequence of his plea. Okay. So what does it mean is understand the nature and consequence. So pursuant to our case law, understand the nature means you know you cannot appeal. You know the maximum sentence will be imposed. So the question, if they tell you, oh, I thought I plead guilty, lighter sentence will be imposed, then this is not understand the nature. Okay. And also, the so-called understand, you must be unreserved, unqualified, unequivocal. In this case, Munandu versus PP. So interesting facts to highlight is that in this Munandu, the court asked him, are you plead guilty for stealing the bicycle? So he said, yes, I admit, but I was drunk. So when you say but, subject to some condition, this is not unreserved, unequivocal. Therefore, the plea shouldn't be accepted. So this is the case I can highlight to you. So back to our questions. They say, is it safe to accept or not? Of course, we say, section 173 say the court can accept. But to make sure this is safe to accept, then you must make sure understand the nature and consequence, and then you put the case law, which is Levin Tan, and also put some cases to further explain how to make sure it's safe. Then you can get your 10 marks off. Of course, you can elaborate more lah. But I think, let me see. Okay, because the facts do mention the OKT was not represented, was not represented means he doesn't have a lawyer, but it doesn't mean he don't understand the nature and consequence, okay? You cannot say, oh, I don't have a lawyer, so I don't understand, unless you betul you don't understand, okay? So in PP versus Tan Tian Chai, the Supreme Court held that the accused himself must plead guilty or claim trial, not through his counsel, as long as he understands the nature and consequence of his plea. So which means it's not necessary to ask the lawyer to plead for you or must be represented by lawyer. Then only you can plead. Okay? So this is our question 1D lah. In order to get your 10 marks, you must write general rules, explain the sections and those case law. Okay? So again, if you guys need any explanation, then you write in the chat box. I will explain. Then we go to our question 2. So the PJ Magistrate Court issued a search warrant on the basis of the letter of application by ASP Monta. The investigation officer, IO, on behalf of the head of Criminal Investigation Department, Selangor, in the application, it was stated that the police require a search warrant to search private premises named in the application to obtain certain items which were required for investigations. In the annexure to the application, the police listed the item required for further and more effective investigation. The search warrant that was issued by the magistrate required the police to produce immediately before the court whatever item listed in the annexure that had been searched and seized from the premises. 2 days after the search of the premises, the seize of the item from the premises, the ASP Mokhtar informed the magistrate of his action but did not produce all items before the magistrate. ASP Mokhtar only returned the search warrant. So in short, the whole fact is saying that they want to search for some places. So magistrate court say, okay, you can search, but you must search and then seize those items immediately produced before the magistrate. But the IO didn't do so lah. They only search, but they never produced the document before the judge. So, okay, I see a questions. Can I still add the option that the prosecutor also may file the case in either sections of magistrate court for question 1B? I think, okay, of course, for the higher level, Sessions Court and High Court definitely will have the jurisdiction to hear whatever matter able to file in magistrate court. But because it's an exam purpose, I would think it will be better if you can answer the right place to be filed. Of course, if I say can file in Sessions Court, then this case also can file in High Court, right? So I think for 5 marks, we better don't talk so much of things. Just focus to the point to say pursuant to what sections and is within the power of the which court, then you go for that court. Unlike if you are talking about silver, let's say the Section Court had unlimited jurisdiction to trial the dispute between landlord and tenant. So although we know Section Court can only hear the matter up to 1 million, but let's say the dispute between landlord and tenant is more than 1 million. But because of the exception, you can still hear in Section Court, then that answer is nice because you mentioned general rule, you also mentioned exceptions. But for these questions, 1B, I think you can just straight away focus to say magistrate can hear the matter because it's only worth 5 marks. Okay? So back to these questions, the question is asking whether the search warrant was issued in compliance with the law. Honestly speaking, when the first time I see these questions, they ask whether the search warrant was issued with complied with the law or not. I have no idea what to answer. Because you see, they talk about so much of facts to tell you, okay, I get the search warrant, but then I didn't comply. But then they ask you this kind of like questions so general, just to say, is it complied with the law? Okay, so as usual, if you attend the past year questions or during the exam, when you see some question you don't know, I think you can have this kind of mindset. Number one, whether this is answerable by statute or sections, either CPC or ROC, depends on which subject you are doing. Number two, is this question require some further explanation from judges or from case law? Okay, so if they are required from case law, unless you know the case law, like for example, B, assuming the search warrants were issued in compliance with the law, whether the police had complied with the requirements stated in the search warrant, and no, if no, the effect of such no compliance. You see, when they say, oh, no comply, what would happen? This kind of thing, usually statute wouldn't able to answer one because it's a hypothetical situations. It usually is happen in case law, and we need the case law to answer. So these kind of questions are when you attend a question in the exam, when you know it's required a case law and you don't know the case law, it is not advisable to do because you see 15 marks. Although you may correct you to argue whatever point, but I don't think you are able to get 15 marks or 10 marks because they really betul-betul want the particular case law. So in the exam, remember to analyze if you are able to answer from statute, which means when you flick statute, you are able to find the law, then okay, you can go ahead. But these kind of questions, if they want case law, unless you know the case law, otherwise you don't do. Okay. So back to this one, whether search warrants were issued complied with the law or not. Then start from the statute first. What sections say talk about search warrant? Okay. So the search warrant I can show you will be section 54. I download the sections also. So in the meantime, you guys also take up your statute book, go to section 54 of CPC. Okay, so this is section 54. So as you can see from the title, when search warrant may be issued. So obviously telling you when can we issue a search warrant. So A, when the court has reason to believe the person to whom summons under section 51 or requisition under subsection 52 has been or might have been addressed will not or would not produce the property or documents as required by the requisition. I think many people who may not understand section 51, so here I will explain. So just like civil procedure, if you want to see some document, you want to inspect some document, then you can do discovery, right? So this section 51 and section 51A is the similar sections to our discovery in civil procedure, which means, let's say today I'm the prosecutor. I say, okay, you on when you stealing stuff, and I got CCTV who capture your face. So you as a defendant, then accused you wondering when did I went to this shop, when did I do this thing? You want to see the CCTV, then you can actually request the document under Section 51. So what is the difference between Section 51 and 51A? 51A is a compulsory provision to ask prosecution before go to trial. Whatever evidence the prosecution want to use must give a copy to the defendant or the accused to prepare their defense. So Section 51A is those evidence the prosecution would use. But on the other hand, what if the prosecution got the CCTV, but he doesn't want to use it as evidence, but you as an accused, you want to use this CCTV or you want to inspect the CCTV, then you can use Section 51. Okay? So if we understand this Section 51 back to here, it means, if I translate to layman meaning lah, which means when you or the prosecution ask somebody to give the evidence, to produce the evidence under Section 51, and you believe that person wouldn't produce under Section 51, then the court can issue the search warrant. For example, I say I was, the prosecution alleged I commit some offense. So then I say, no, I wasn't on KL that day. I was in Perak, let's say. Then the prosecution say, okay, then you show me whatever proof that you are in Perak. Then when they ask me to produce under Section 51, then I refuse to produce or I don't want to produce. So then they can use this search warrant, go and search my premise in order to get that particular evidence. Because they believe I wouldn't produce, so they can search under Section 54 sub 1 sub A. Okay. Then B, the property or document is not known to the court, to be in the possession of any person. So which means the court don't know where is the evidence, but we believe in the particular premise or particular place we can find, then the court issues search warrant. So this one is like wider lah. Then C, the court consider the purpose of justice. So I think it's justice, for the justice. Then I issue search warrant. Okay. So after we talk about so much thing, Section 54, whether search warrant was issued in compliance with the law, then back to here. Why magistrate issue the search warrant in the first place? Is because the police want to search the primary premise to obtain certain item. So, pursuant to Section 54, cannot. Memang what? They want to search for something. So they indeed comply with Section 54. I really looking for something. I want to search something. It's not suka hati. I feel like I'm happy. I search. It's because I have some reason. So you can write like this. Pursuant to the law, what should do? ABC. Then on the facts, they want to search for an item. Okay, then apply to the law, we can do that. So this is how you answer when you don't have anything to support. We just based on section to answer. So you should have this kind of like structure case, facts, law, facts, your opinion, or application, how you apply the law. Okay. But since we are doing past year questions, I can share with you is that actually they do have some case law for these questions. So why I say so? You see, the question I asked whether search warrants were issued in compliance with the law. So, like I pointed out just now, pursuant to Section 54 sub 1 sub A, it provides that a court may issue search warrant if the court has reason to believe the person under Section 51 would not produce the property or document. So in that case, you can issue search warrant, fine. But in this case, N. Indra, anak perempuan P. Naladabi, if I pronounce correctly the High Court held that Section 51 must be applied first before restoring to the use of Section 54 sub 1 sub A. So what does it mean? If any of you attend the past year question last year, you will notice, right? N. Indra. This case actually happened in came out in last year past year question CPC also. It's about the what we call whether the search warrant can be signed by juru bahasa or not, can be signed by registrar or not, if any of you remember So you see, this year they last year they asked again this case law. So I suggest if you guys may look into this, read these facts since they asked twice already. So in this case, they say before you issue search warrant, or you say, I suspect this person will not produce under Section 51. That's why I want search warrant. This case, the court say, then you must at least apply Section 51 first. You must at least ask him or her to produce. If you fail to produce, then only you can justify to say, I reason to believe he wouldn't produce under Section 51. You get what I mean? So I give you an example lah. Let's say I have a student do tuition with me. So I say, hey, have you paid my tuition fee? So he say, I paid on when and when. Then I say, can you show me the evidence? So cannot be before I request under Section 51, ask him to produce the receipt. I straight away ask the court to search, issue search warrant, go to his house and then search and then seize the evidence. We must at least give a chance first. Section 51, give a chance first, ask first. If you believe you do already, you still think he wouldn't produce, then only you ask the court to issue search warrant under Section 54, sub 1, sub A, because you have the reason to believe he wouldn't produce. Okay, so this will be the answer lah, the perfect answer lah. But if without the case law, also you guys can answer like what I said just now. To say 54, what situation you can issue, on the facts, why you want to issue, and third, whether you think it should be able to issue or not, because the police want certain item. Is it justifiable to issue? Okay. Then I go to next one. Assuming that the search warrant was issued in compliance with the law, whether the police had complied with the requirements stated in the search warrant. If no, the effect of non-compliance. Okay, again, like I said, must think about whether you can answer based on statute or case law. Must need a case law. So let's say we don't have any case law. Assuming search warrant issued in compliance with the law, which means we comply with Section 54. Okay, we go ahead. But the police did not comply with the requirement. So what is the requirement here? The requirement here is you must produce immediately before the court. So on the facts, the police didn't do so, right? Didn't produce, right? So understandable lah. When the court asks you to do, but you didn't do, what do you think will happen? Logically, of course, you don't comply, then it's a breach of law, then it's not acceptable. So what is the effect? Then whatever evidence seized, maybe is suspicious, maybe is unreliable. Therefore, we cannot use it as an evidence in court. This is the without case law argument lah. Okay. So, but 15 marks, definitely I think they need a case lah, because like so particular, so precise, like they really want to know something. I think this is for case law. So the case law will be it is clear that the police did not comply with the requirement in the search warrant, i.e. produced immediately before the court. Whatever item listed in the annexure that has been searched and seized from the premise. So again, in an indra, the High Court ordered the police to produce the item forthwith. Forthwith means immediately with the magistrate court. So if you ask me without the case law whether you can answer or not, can lah. You say understandable ma. What, you didn't comply? Then what is the consequence? It's not admissible, it's not reliable law. But by answering that, of course, you cannot get 50 marks. I don't think so lah. But with the case law, then you can further say law. In this case, same thing happened. The court just asked the police immediately produce before the court without saying that the evidence is inadmissible. So this is the effect happened in this case lah. Okay. So if this question really happened in the real exam, this is not advisable to do lah, because they need a case law ma. But since N Indra appear 2 times in the past question already, I think you guys can have a look lah. Okay. Then we go to question 3. So on 10 April 2023 at about 6:15 p.m., a team of police officers headed by ASP Abu raided the premises of a BTS publicizing Sendirian Berhad in Breakfield based on the information received by the police. During the raid, the police seized 2 books written by PTS. Upon pursuing and checking the contents of the books, ASP Abu arrested PTS, who was in the premise. BTS was informed the content of his book tender to bring hard-headed, condemn or cite disaffection against the government and the administration of justice in Malaysia. He was taken by ASP Abu to Palai Police Tan Wangi. He was kept in remand that night. No statement was recorded from him. The following day, he was brought before a magistrate. He was ordered to be remanded in the police custody for 1 day. After hearing his statement recorded by the police, BTS was released the day after. There was no other investigation carried on BDS other than recording his statement, BDS will also not charged for any offense. Okay, examine whether the arrest of BDS was lawful. So, although they mentioned a lot of things, but actually the only thing they want to ask you, actually nothing much about he been arrested and what he was arrested, nothing much is whether the police can arrest you, remand you, and then at the end release you without charging you. Is it okay? I think the concern is that if you say can, then what if the police just want to catch you? They just catch you, put you in the jail, not jail lah, like lockout. Then after that release you without charging you. Okay, so of course we are law student. Whatever we say must based on law lah. So number one, whether a police can arrest someone or not, I think the answer should be yes lah. Why? Because if we refer to arrest chapter, okay, power to arrest, section 23, expressly section 23 sub 1 sub a, where any seizable offense has been committed, any police may arrest any person without warrant against who? A reasonable complaint has been made. B, a credible information has been received, or a reasonable suspicion exists. Okay, so then you will see the keyword in the questions. Information received. So I think if I were you, then I would say, pursuant to section 23 sub 1 sub a, if we receive information, credible information, we can arrest. So arrest is fine. Okay. Then after arrest already, you can remand or not. Of course, answer is yes also lah. As long as you comply with the diary, 117, 119, whoever don't know this, let me know. Then you can remand the person. So you can 1 day. Okay. And then once the police arrest, remand already, what they need to do? They will submit the report to the public prosecutor. And it's the public prosecutor to decide whether want to charge PDS for any offense or not. So, like I said, the question is so much about whether you can arrest and then release without charging anything. My opinion is that it's totally fine, because whether to charge you or not is not up to the police. It's up to the PP. The police is more like the person who just do the report and then submit to their boss, which is PP. Then PP decide whether they want to proceed or not. If PP think there's no case to against this person, then they wouldn't proceed. So I would say the arrest is totally fine. So the structure will be section 23 sub 1 sub a, and then remand order a little bit, and then lastly mentioned, it's up to PP whether to charge or not. It's nothing against any person. Everything is about procedure. Okay. So of course, one case I can highlight is that Muhammad Azram bin Rahman. So in this case, a FIR was lodged by a complainant. A person has trespassed in the premises. The appellant investigated, arrested, and detained the respondent, but then released him later without charging him. So then the person not happy lah. He claimed damages against the appellant. High Court awarded general damages and exemplary damages to the respondent. The appellant appealed. Court appeal allowed the appeal, and on the grounds that when the FIR was lodged, the appellant was bound to investigate and give status report. Hence, arrest and remand and detention was lawful. Which means in this case saying that just because you was kena complain, kena arrest, it doesn't mean at the end no charge. It means this is unlawful arrest. Because like I said, this is all procedure. The police, whatever, they are just doing the job. When people lodge, they need to do their job. That's it. Nothing personal again. Okay. So same. Whoever don't understand, just let me know. Right in the chat box. Next one. Commencement of the criminal trial ought not to be delayed. Okay. Muhammad Nazlan, Muhammad Ghazi Justice. So I think whoever like the theory thing. So you see, commencement of criminal trial ought not be delayed. What will happen if the criminal trial delay? You will continue to stay in lockup. You will continue to carry the name that you commit offense. So for this is 5 marks. So if you ask me, I would say ought not to be delayed because we want to clear our name. And the law is not to create harshness on the people. Just because you suspect I commit offense, it doesn't mean you can delay the thing to make me suffer more. So of course, ideally it should be dispose the case as soon as possible. 5 marks only, so I think you guys can go and correct a bit. So my suggested answer will be, before initiating criminal proceeding, we must understand that the purpose of criminal litigation is to achieve a platform for maintaining social order and personal security. Following the principle of presumption of innocence, we must expedite the criminal trial as much as possible, considering the deprivation of accused personal liability. So, presumption of innocence, I think everybody know, right? Which means everybody is presumed innocent until proven. So, before you prove I'm guilty, I should be presumed to be innocent. So when I presume innocent, I'm still no guilty man. Then you shouldn't restrain my personal liability. But of course, you guys also worry I may run away. So ideally, like I said, it should be settled or should be hear the matter as soon as possible. If the intention of transferring a case is to delay the commencement of the criminal trial, and the public will be none the wisest and probably from the perceptions, perception that the court system brief insufficiency and delay, even or especially the high-profile cases, which are the ones usually seek transfer to the High Court. So this one is referring to those like Nagi case, those big case. They always like to delay. I don't know who you guys know or not. When I was practicing lawyer first or second year, that time Najib case just started. So then I heard a lot of laymen keep telling me, hey, why Najib haven't go to jail yet? Why Najib still no got to jail yet? Actually, many people, they don't know. They always thought like the court delay. Actually, it's not the court delay. It's because of Najib lawyer tried to apply the extension for many reasons. So because of the Najib, and that time also the adjournment chapter, I show you. So last time we can adjourn the case, just mentioned to say you can adjourn the case. But ever since the Najib case, then they come up with the practication. They say it's only unavoidable circumstances you can ask for adjournment. Otherwise, they don't give anymore. So last time they didn't expressly say unavoidable circumstances, but now they say must be unavoidable circumstances. For civil case, they even added the situation to say you can only give adjournment 3 times, only 3 times. Okay? Yeah, I see your questions are. Question 3B. Will be given enough, will be given even though I don't know the case mentioned in question and just scoring. Okay, I think should be okay because number 1 is only 5 marks. So I think you can scoring. Okay. Number 2, 5 marks actually you just justify to explain why you think agree or disagree the criminal shouldn't be delayed. I think you can easily get ready. If you agree, then you say interest of justice, liberty shouldn't be restrained, innocent until proven. I think you correct a bit, you can get ready. But if you say you disagree, I don't know how you want to correct, but you disagree, you can say, everybody time also precious. The court also got many cases. You cannot say we can only focus your case, something like that. So I think you don't need to know this case, you can answer because it's only 5 marks. Okay. Then I go to next one. The accused were charged at the Kuala Lumpur Section Court with 5 charges under Section 4 of the AMLA. Not AMLA, MANLATFPUAA. Okay. The accused applied to the High Court for transfer of his case from Section Court to High Court. The accused advanced a number of reasons to support his transfer application. Okay. Firstly, the question of law unusual difficulty will likely to arise as the trial will involve a complex and novel question of law, including inter alia the provision of ANLATFPUAA. Since the offence was allegedly committed outside Malaysia and might involve issue or extraterritorial jurisdiction, cross-border transaction and admissibility of evidence from foreign country. Okay. Secondly, admit the student. Okay. Secondly, the accused argued that since the High Court at Kuala Lumpur has previously allowed a criminal proceeding like the 1NDB case to be transferred from Section Court to the High Court, on the basis that the case raised complex question of law, it should follow the application. Okay. Thirdly, The accused argued that the transfer of case will be expedited for the end of justice and will ensure the applicant constitutional right to a fair trial is preserved. Okay. So I think quite obvious this is asking transfer of case lah. So can we transfer from Sessions Court to High Court based on these three reasons? Okay. But I think being exam is exam lah. So always remember, all judges are so hardworking to the extent that they don't want to let go their case. They will still say, I want to hear this matter. So please do have this mindset. So although they mentioned a lot of things, I think the best answer will still say, you cannot say Sessions Court cannot hear this matter just because of the complexity. Because if you say that, in the way you are saying the High Court is smarter than the Sessions Court. Okay, so I think my suggested answer will be, in this case, Riza Shariz tells that it is clear that the discretionary power to transfer the case under Section 417 is vested in the High Court. The accused must show that the question of law is truly and exceptionally difficult. The likelihood of reference of ANLTFPUAA does not by itself neglect the competence of the Sessions Court in dealing with the issue which may arise during trial. Allowing the transfer from Sessions Court to High Court may cause delay in commencement of the criminal trial. The High Court emphasized the importance of maintaining judicial efficiency at all times. So if you guys smart enough, then you will see Riza Sari, which is this case. So basically in this case, it's a correlated one. They are saying that, like I say, you must always say, or you cannot deny to say High Court judge is smarter than Session Court judge, number one. Number two, just because there is a difficulty, it doesn't mean the Session Court cannot handle, because Session Court can hear all matter except that penalty. So this like makan money, breach of trust, don't need to send for that penalty. The Session Court can still hear the matter. So for what reason you say Session Court cannot hear this matter? So I think this one you can correct a bit to say, like I said, the good answer will be to say Session Court remain has the power. If you guys remember, there is a case law also. They tried to transfer from Sabah Sarawak to KL, I think. Then at the end, the Session Court also refused. Let me see which case. This case, Datuk Haji Wasbi. So although the Session Court say no, I still have the power to hear this matter. I don't want you to transfer to KL. This case also say never mind, okay, and cannot appeal also. So that's what I say. Must presume all judges are so hardworking until they don't want to let go any case. So then this will be the answer, the best answer, I think, better answer for this kind of questions Okay, okay. I think without the case law also you can answer like I say, you cannot deny to say the competence of the Session Court is not better, it's not better than High Court Okay. Then I proceed to question 4. On 10 March 2023, a company director was charged with 6 charges under Section 409 of the Penal Code. The company director, who was represented, pleaded not guilty and claimed trial to all charges. The Sessions Court judge allowed the company director bill at 500,000 with one surety, and additional condition that he surrender his passport. The judge also set 7 April 2023 for mention. I don't know you guys know for mention, what does it mean? Actually, for mention is the meaning case management for civil case In criminal, they don't call case management, I think they call mention So in civil, they call case management. Okay. So in the same court, a traitor was charged with 2 counts of cheating under Section 420 of the same code. The traitor was unrepresented, claimed trial to the charge. The SCJ allowed bill of 10,000 with one surety on both charges and ordered the traitor to surrender his passport to the court, as well as to report himself at the nearest police station every month. The judge also set 7 April 2023 for mention to allow traitor to appoint an advocate. Okay. Explain the duty of the advocate representing the company director in relation to the pre-trial conference between 10 March 2023 to 7 April 2023. Okay, so whoever, if you have studied already, then you should know pre-trial conference, section 172A. So if you refer to section 172A, they got list out all the thing you need to do in the pre-trial conference already. So basically pre-trial, like the word suggests, pre-trial, before start the trial, conference, meeting. So before start the trial, we need to have a meeting to do what? Clarify with the accused position, which means whether you want to admit or don't admit, whether you have committed the offense or not, okay? To say what is your position. Ensure comply with section 51A. So like I mentioned just now, what is section 51A? Before go to trial, the prosecution need to give you a set of evidence they want to use, and then discuss the nature of the case, including alibi. So like whatever case facts you can mention, discuss the plea bargaining. Plea bargaining the price. So the bargaining here is like, can you admit? If you admit, I can tell the court, give you lightened sentence, etc. Reaching any possible agreement. And E, other matter as agreed upon, which may lead to the expeditious dispose of the case. So basically, it's like a meeting to discuss whether we can settle or not. Malaysian like to settle, okay? So I think this one, nothing much. We can just copy from the section and then give some illustration. Okay, give some example. Always remember, if you think your answer is too short, or you just copy from the statute, give example, give illustration. Okay? So, in view of the fact that the traitor was unrepresented, explain the SCJ must do in relation to the case management process. Okay? So, what you need to do if they are unrepresented. So, of course, number one, tell them you are entitled to a lawyer. Okay? Number two, read and explain to him section 173A. The first thing you must do in the summary trial. Read and explain. Make sure he understands. Number two, remind the trader he entitled to defended by an advocate and solicitor 255, and ensure the trader is accorded a fair trial by the court. Okay, so this is the three things for 5 marks. I think for 5 marks, each mark you write and then give some illustration, enough for you to get 5 marks already. Then, with the aid of the case law, explain what hunch is and whether it's suffice to impeach the credit of the witness. Okay, I don't know if you guys know what does it mean, hunch, if I pronounce correctly. My understanding to this word is a feeling, which means people haven't do this thing yet, but you feel they will do that. Okay, so in other words, can you just based on feeling to impeach somebody credit? Okay, so this one memang got case law, no choice, because 30 marks. Okay, so the case law is Dato Mota Hashim. Explain that a hunch is a pre-sentiment, a mental impression or feeling, a vigorous expectation of foreboding, and we would like to make abundantly clear that the hunch referred to in Husi is another case law, certainly could not have been intended to operate without some secure basis or foundation in order to activate the provision of section 145 and 155. Okay, let me translate to layman language. It means that a hunch is just a feeling. You cannot base on the feeling to impeach someone without some basis, without a secure basis or foundation. Okay, and for the purpose seen institution of counsel will not suffice. A mere hunch per se for the purpose is, I don't know how to pronounce Latin. It must be secure on a substantive of some basic or foundation. They must, again, I don't know how to pronounce Latin, some material contradiction or other circumstances unexplained by the witness in the first instance before counsel can move to seek impeach his credit. So in short, he's saying that usually we cannot base on feeling to impeach someone. You must have some material contradiction. For example, at first you say the car is red, later you say the car is green. This kind of contradiction, then only you can impeach. So of course, for 30 marks, you need to say all the general rules. So general is what? We can impeach someone where, I show you, number one, testify that he is unbelief or credit. So you feel that this person cannot be trusted. Number two, you feel this witness has been bribed. Number three is the most often come out in the question, inconsistent. Previously say A, now say B. So because it's 30 marks, so you must explain from the start. Then you say, if it's a contradict previous statement, it can be written it can be oral. Then only you mention the procedure lah. To say must be material discrepancy. Then only you ask for the leave of court. Then the court will give the chance to ask them to explain. Then see whether the explanation is acceptable or not. Then only they give a decisions lah. Okay. But of course, at the end, you must cite the Dato' Moda Hashim to say lah, feeling is not enough lah. Okay. So I see your questions are. Question 4A Roman 2. 4A Roman 2, okay. In question is relation to CM process. Can I write section 172B? 172B. Just let me have a look at 172B. (172B) sub Roman 2. Okay. Thank you. Thank you for this. I don't know your name. A. Yes, okay. Our friend A highlighted a very good sections. Section 172, capital P, sub 2, sub Roman 2, and sub Roman 3. As he sub-highlighted, is a case management process. So case management process, then we can refer to 172 capital P. Then I think that answer will be better, even better than my one. Okay, thank you, thank you. So okay, for B also, I say feeling is not enough to impeach for 13 marks. I think this question actually quite okay also lah. You may not know Dato' Moda Hashim, but I think by explaining the procedure, all that, it should be at least can get 7 or 8 marks. Okay. Then we go to section 5, question 5. Just a moment, too hot. I on my aircon. Okay, so Taiko has been charged for offense of causing grievously harm punishable under section 326 of the Penal Code at the section called in Mua, Johor. Mua, okay. The facts of the case reveals that on 22nd February 2022, Taiko has abused his wife by causing grievously injury. The trial has commenced. However, at the midway of the trial, Taiko pleaded guilty to the charge. Okay, plead guilty. At the end of the proceeding, upon hearing the mitigation by Taiko counsel, Injek Buta, the aggravating factors by the DPP, respectively. Okay. Again, I assuming you guys will know what is aggravating factor and mitigating factor. But for class purpose, I will just quickly explain. So, whenever there is a judgment already, before the court give a sentence, you as accused will raise mitigating factors. It means whatever factor you ask the court to take into account to reduce the sentence. This is mitigating factor. But on the other hand, your opponent, prosecution, who want you to die, they will raise aggravating factor, which means they will highlight to the court what factor need to consider to make the sentence more heavy. Okay. So in this case, after they hear the mitigating and aggravating factor, Tuan Ade, trying the case, decided to release Taiko on bond of good behavior pursuant to 294 of the CPC. Okay, 294 is the good behavior. The DPP then filed an appeal against the sentence at the High Court of Imwa. Meanwhile, the Leonard High Court Judge of the High Court Imwa, Yan Arif Adil, decided to call out the matter for revision. So it means when they appeal, then the High Court also want to call for revision. So could the High Court, Yan Arif, call for the matter for revision in view the appeal filed by DPP? Okay, I think understandable is that when people appeal, you also want revision. Isn't it they will have two decisions? Generally, it shouldn't allow generally because later, what if your decision for revision and also the appeal come out two outcome? But 7 marks question being questions I think I highlighted in my Facebook also in Oi Hun Seng, the High Court tells that since the revision was a step in it and was not a continuation of the trial of the appeal, then it should not be any impediment for the application to be filed, even when there was an appeal pending, provided the application was made bona fide to correct a miscarriage of justice. There was no bar to the court in hearing the merit of the application, notwithstanding an appeal was pending, and the appeal sought to impound the decisions of the court. So basically, in this case, they say, although you may appeal, they can still go for revision. But this one is against my logic because my understanding from this case, Muhammad Daha bin Rizwan says when there's appeal, you cannot do revision. My understanding is that, like say, what if come out two decisions? But like I said, exam being exam, so you just remember, one case says can, one case says cannot. Just a tip sharing with you guys. When you memorize those cases, don't memorize too much. Just memorize one case says can, another case says cannot. Then when you go to exam, then you can scoring, right? With two cases, I think you can scoring 7 marks, right? Just says what is the position, and then exception is what? Ultimate 7 marks. Okay. Then discuss as to the legality of the sentence meted out by the learned session court judge Tuan Adi. Okay. So what's wrong with his decisions? He hit his wife, domestic violence, but the court only asked him to good behavior. Can it be do so? So if you guys refer to section 294, so 294 actually wait, let me flick to 294. 294 is the wording is first offender. So basically they say if you are first offender, we can give you chance to not go to jail yet give you another chance not to commit this offense again. But these questions please remember come up many times already if you go to 294 sub 6 sub 6 2 mentions this section shall not apply. Number one, the offender is charged with serious offense. Number two, if the offender is charged with the commission of domestic violence. So if you hit your wife, you shouldn't go for, you cannot give good behavior. Okay. So again, I want to highlight to you is that 294 294 is good behavior Another section is 173A. Okay, so we have two sections for good behavior but the difference is 17A usually is for government servant This is what my lecturer say not I say because honestly speaking, when I read section 17A I didn't see this wording say this section is only for government servant, but my lecturer say so okay. And then if you use 173A there is no commission recorded, but if you use section 294 commission will be recorded okay. But both sections also got the sub provision to say you cannot get good behavior if the offense is serious offense or domestic violence This kind of questions are being asked like quite many times already because 17A sub 8 and 294 sub 6 is a new provision. If I'm not mistaken, it's added in, let me see in which year 2016. So it's after my year So they like to ask this question because it's a new provision. Okay. So take note this question been asked a few times already. Then what are the likely order that may be made by the High Court when exercising the revisionary power? Okay. This question also asked many times already. Please take note. The revisional power is when you use revision, what order you can make. Okay. Of course, number one is to call for the record CPC you can refer. 323 322 324 order further inquiry okay, these two is normal, just copy and paste. But 325 I think is worth to highlight. Number one, you can grant a stay for executions. Okay. Number two, you can arrest the respondent in appeal against acquittal. Okay. Number three, power in 316. So what is 316? 316 actually is the power when you appeal. When you appeal from lower court to high court, what are the order can be made by high court during appeal is 316, i.e. Dismiss the appeal. Okay, reverse or such order of acquittal or find accused guilty and pass sentence according to law. And in an appeal from a conviction, reverse the finding and acquit and discharge accused or with or without altering the finding or reduce or enhance the sentence. So this is all the power in 316. So you guys can find in 316 CPC. So if you back to the power of revision, you see, one of the power for revision is entire thing for appeal. So which means the power for revision actually is wider than appeal. Because whatever you can do in appeal, I can do. I can even give stay, I can even arrest, I can also take fresh evidence. Okay, so this is the thing the examiner want you to write 325 just copy and paste. But because I know when they write in the wording, this is more complicated but you need to use your own wording to explain. Okay, so my answer is the same 325. Okay, remember 316 is entire power for appeal. This question asked a few times already. Okay, then question 6, Catherine was charged for 2 offences of corruption at the Sessions Court Shah Alam, Selangor. During trial, 17 witnesses for the prosecution have testified in open court. In the year of 2023, Cashwin, through his lawyer, Mr. Adib, made a representation to the PP to have the charge against him withdraw in the view that the facts there has been a material change in the circumstances of the case involving Cashwin, which has affected the foundation of the charge against him. Foundation of the charge. Okay. The prosecution agreed to the withdrawal upon the application being made by the prosecution in open court. Sorry. Let me deal with this. Okay. Allowing the section court allowed the withdrawal of the C charge and consequently decided to acquit and discharge Cashwin for all charges against him. Okay. So question, the validity of order of acquittal and discharge made by the learned SCJ. Okay. So since they agree to withdraw, I think no issue to acquit But the problem is acquittal or discharge withdrawal there is 2 types of withdrawal we have which mean DAA and DNAA. If you guys follow all the news our deputy prime minister what is the name I forgot the name already. Zaki Zaki get DNAA. Just sharing with you in case asked in the exam because since our CLP always like to ask those latest news So Zaki basically being charged for criminal. I think been charged for 5 years already if I'm not mistaken. Then now TPP suddenly say, oh, we don't have sufficient evidence. We want to withdraw the case. But when they withdraw, they want to reserve the power to charge Zaki again. So they got DNAA, the charge not amounting to acquittal. So remember Zaki case. So, but on the other hand, if you get DAA, the charge amounting to acquittal, it means the prosecution cannot charge you again already because it's amounting to acquittal. Thanks, Usa. Thank you for telling me the name. I don't know if I pronounce your name correctly. So DAA means it's amounting to acquittal. It means like you been acquittal, the prosecution cannot charge you again. But DNAA, on the other hand, is not amounting to acquittal, so you can be charged again. So in this latest case, 2022 case, Merit Lim, FCJ, held that the plain and clean meaning of the phrase such discharge shall not amount to an acquittal unless the court so direct in section 254 sub 3 was that the court had to specifically direct the discharge did not amount to an acquittal. Otherwise, the default position was that discharge amount to an acquittal. So what does it mean? It means if the court didn't expressly say so, the general should be DAA. Which means back to this question, because they just say discharge, but they didn't say it's DAA or DNAA. So if we follow this latest case, federal court case, if the court didn't say it's silent, then it's DAA. This case actually changed the positions. Last time is you must say, then only is DAA. Otherwise, the general is DNAA. But now they change already, they terbalik. Okay? I repeat, last time is if the court didn't say, is DNAA. But now is if the court is silent, acquittal means DAA. Means your acquittal, you cannot be charged again. Okay? Then B, the legal provision available for the prosecution to make application to withdraw the charge against Cashwin. Okay, so the provision 5 marks only we can straight to the point. 2 provision. Number 1, 254, like I mentioned just now and 171. These 2 provision only. Okay, so 2 provision, nothing special. I will proceed. Sorry, click wrongly. Yeah. Okay, so if not for the withdrawal of the charge against Cashwin by the prosecution, when can he be possibly discharged by the court on the charge against him? Okay, so if you are familiar with summary trial, the summary trial will be written at, I show you my notes. Will be number one, read and explain. Number two, plead guilty or not. If not guilty, proceed to trial. Then the court decide whether there's a prima facie case or not. If there's a prima facie case, the accused enter defense, then the court give decisions, right? So if without withdrawal, no withdrawal, but then the material change in the circumstances affect the foundation, what will happen? What will happen is no prima facie case. So the next he can be discharged is after the court hear the prosecution case already, the court say no prima facie case, I let you go. Section 173 F, no prima facie case. Or alternatively, 173G, the court discharge Cashwin at any stage if the court consider the charge is groundless. So groundless G, 173G. So we have two situations, two provision can allow the court to release or discharge Cashwin. Number one, no prima facie case. Number two is groundless. Okay. Then D, assuming if the session court judge decided to give an order of discharge not amounting to an acquittal, can the prosecution in the future reinstate the trial against Cashwin and continue with the rest of the witness? The answer is yes, because it's DNAA, discharge not amounting to acquittal. Okay, so this one I think I have explained just now already. 5 marks. Just write the law, give some illustration, then we can continue. But if you want to write more, I think you can go for this Latin. I don't know how to pronounce that. Okay, this word basically means if you have been acquitted or have been convicted already, you cannot be charged for the same offense again. But in this case, Cashwin cannot apply it for DNA, because in South Sukin says this plea is not available where subsequent charge is for different offense. So for example, last time you are charged for stealing, next time you charge for burglary, different thing, so can be charged again. Or offense occurred in different date, or the first trial was declared nullity. So in our case is they say they don't want to continue. So you cannot apply these sections to say you cannot be charged again because there is no official acquittal. Okay, so it's the NAA, you can be charged again. You can mention these sections. Okay, and we go to our last questions. Multiple, age 53 years old, charged with 7 offense of forging valuable security document to transfer property to himself, punishable under section 467, and another 5 charges of offense of cheating under 420 of the Penal Code at the Session Court Seremban, Negeri Sembilan. All offense were committed over the period of 3 years. So you see, so many offense also mentioned the period already, then we know, which is joinder of charge. Whoever who don't understand duplicity of charge or joinder of charge, I just briefly explain here. So if you go to charge chapter, we got this thing called rules against duplicity of charge and rule against joinder of charge. What does it mean? If I may translate to layman terms, duplicity of charge means one offense, one charge. Joinder of charge means one charge, one trial. Okay, but please don't write this in your answer. I got students who write this in the answer to say rule against duplicity means one offense, one charge. Hey, don't this is too layman already. We are professional, so write in the professional way. But like I said, this is layman terms. Duplicity of charge means one offense, one charge. Joinder of charge, one trial. Okay, so witness at the trial testified that they were deceased by the accused using forged valuable security document to effect the transfer of the same property to the accused. All trial charges were jointly trial at one trial. All offense, like I say, one offense should be one trial, but because they all put together, together means 7 offense and 5 offense for cheating. 7 offense for forged document and 5 offense for cheating. Okay. At the end of the trial, Puan Nazihah, the section court judge, committed multiple and sentenced him to a total 16 years imprisonment and 2 stroke of for each of 12 charges. Whipping of 2 stroke. Okay. 12 times 2 is 24 lah. Okay. So what is the purpose of charge and the basic requirement? This one also away they ask lah. So basic requirement is what? If I may go to charge chapter, basic requirement is number 1, you need to tell the purpose. The purpose, I think you can memorize a few cases lah. But mainly, the purpose of the charge is to tell the accused what offense we are charging you, what kind of defense you need to prepare. So the purpose is like that. This is for accused. For the prosecution is they know what kind of element they need to prove. For example, murder. So they know they need to prove adversarial, manslaughter, etc. And for the court is the court will know how many years of imprisonment he can send and also what section he need to refer. So for different party got different purpose. Okay. And the basic requirement, I think quite straightforward, you can remember is number 1, you must tell what is the offense. So the offense if there's a specific name, you need to write the specific name. If there's no name, then you need to use the definition or the description under the sections. This is number 1, first requirement. Number 2, you must say the punishable section of law. So as you can see, every time the judge must tell you, you are punishable, liable under what sections. So people know how many years of imprisonment may be imposed. Okay, number 2. Number 3, time, date, and place. So at least you must know when and where. Okay, and number 4, manner of committing offense. So this is the 4 basic requirements to frame a charge. Okay, this question put a star. Ways they ask. Okay, I think right. Number 1, purpose. Purpose can be accused, court, and prosecutions. And then basic requirement, the 4. Law. Sorry, I also forgot. Offense, sections, time, place, and date, and manner of committing offense. The 4 requirements. Okay. Then, advise Puan Nazihah, the section court judge in Seremban, as to whether all 12 charges will be trial jointly. Okay. So, first of all, you must understand, in order to know whether a charge can be trial jointly or not, generally, of course, cannot lah. But we got exceptions. And the exception also divide into 2 types. Number 1 is 1 accused. Number 2 is more than 1 accused. So our facts is only 1 multiplying. So we will focus on 1 accused. So 1 accused, we got 4 exceptions. Number 1 is 3 offense under same kind committed within 12 months. Okay. 3 elements. Number 1, 3 offense. Number 2, same kind. Number 3, 12 months. Don't ask me whether can try 2 offense or not. The answer is yes. 1 until 3. Okay. I got students say, oh, is it like die must be 3 offense only? 2 offense cannot. No, 2 offense also can. So back to the facts. Is it 3 offense? I didn't know, right? 7 plus 5 also more than 2 already. More than 3 already. Okay. Number 2, is it same kind? I think arguable lah. Transfer and cheating is almost the same. Forge and cheating. But is it within 12 months? Because the element is 12 months. But on the facts, 3 years. So cannot. Raise and dismiss. 10 marks. Raise and dismiss. Raise this exception and then say cannot. Okay. Then 165. Same transactions. I think same transaction can. Because what is same transaction means? Proximity of time. Proximity of place. Continuity of action. Continuity of design or purpose. Okay. I know you may have a difficulty to write 1 by 1 in the exam lah. But I can suggest is that you just write to say, oh, pursuant to 165, if the offense commit in the same transaction, we can trial together. And pursuant to this case, same transaction means A, B, C, D. Then straight away apply to the facts. If you are not able to write 1 by 1, like this one, or 3 offense on the facts, no. Okay, 12 on the facts, no. Don't write it. Just straight away say requirement is ABC, blah, blah, blah. Then on the facts, straight away say on the facts, commit over 3 years. Co-related, same within, therefore can or cannot. Up to you to argue. Because I do understand when we speak, very easy, but when we write, is another thing. It's not easy to put in the wording when you want to explain. So, like I said, either you're able to write one by one will be better. If you cannot, just say requirement is what, on the facts, can or cannot. That's it. I think the examiner is smart enough to understand you as long as you write the thing. Okay. So my suggested answer, I think, let me see, can or cannot. Okay, I say the most suitable exception is 165. But with limited information given, we are not sure whether all 12 charges are correlated or not. If 12 charges are related, then they can try jointly in 165. The reason I say not limited information is because if they are all same victim, let's say I tipu you to sign the document, so to achieve my cheating offense, then it's correlated. But on the facts, because they didn't get much info, so we cannot ascertain, we don't know. So I didn't tell. And some more is only 10 marks. I know we like to use the word assuming, but because with very limited information, if you want to assume, you want to assume a lot of things. But if you want to just make it simple, you just say, assuming they are correlated, we can try together. Make it simple also can, because it's only 10 marks. Like I said, 10 marks is only like one page of answer. So don't struggle too much. Time management also very important when you answer answer your questions. Okay. So the last exception I explained to you also since although it's not relevant, if single act of serial or act, then also you can try together. I give you an example. I see you, I slap you, and then I walk over, I steal people wallet, and then I go to petrol station, I pump petrol, I don't want to pay. So all this although it's a different kind of offense, but because it's a serial or act, I do all the while, then all these things can be heard together. Okay, this is 166. It's kind of similar to same transaction actually. But I would say same transaction maybe is wider because they include the purpose and design also. Let's say I create a apps or a website, whoever click, all the money will transfer to my account. So this thing can be last for many years, as long as all is within the same matter of cheating. Okay. Then last one, advise multiple as to the legality of the imposition of 2 strokes of whipping for each 12 charges. So like I said, 12 times 2 is 24. And whoever study already then should know the maximum whipping is 24. Okay, Tuan Mat bin Tuan Loni. But of course, you may have other cases. Okay. And one interesting thing to highlight, whipping is not allowed if it's a woman sentenced to die. You're going to die already, don't need to whipping him, okay? And a male more than 50 years old. So that's why our najib is not the other whipping. But our side sadiq need to whip because he's a remaja, young man. But if you are committing all these offense, which is red people, logo, since you can logo people, then you can must tahan the whipping also, okay? Sir, can we use Pachik Abdul Rahman? Pachik Abdul Rahman is for the whipping also, is it? If yes, then can. Like I said, we got many cases mentioned about 24 stroke. As long as I talk about same thing, it's 24, then you can use. Because I know we got many different kind of cases to mention the same thing. Because some people is from ATC, some people is from BAC. So the cases we use may be different. Okay? So we have settled our main paper 2023. Any question you guys want to ask? For question 5A, I see. Revisionary power can be involved pending appeal as an aid, right? So Yan Arif was right to call the matter for revision following the case of Oi Hun Sek. How to distinguish that will be other way around? Other way around. What do you mean other way around? We mean like is it like when you have appeal, when can you file revision? Is it? Or what do you mean? Oh, okay. The case actually didn't tell in what situation and what requirement when there's appeal, you still can do revision or not. I referred it by a. The question just say it doesn't stop the court to do revision, because revision is an inherent power for the court to do check and balance. But if you insist to have one requirement, I think only this one, as long as the application is bona fide and to correct the miscarriage of justice, which means the court cannot suka hati to do revision, but must be bona fide and to correct the miscarriage of justice. Okay. But I think to make it easier, so far, unless it's essay questions, otherwise, if it's a problem question, they just ask you whether there's an appeal, can I still do revision? Then you cite two case law. One case say can, one case says cannot. That's it. Okay. Anything else? We just wait for 5 minutes, see anyone got any questions. If no, then we will call it a day. So let me see, we got how many weeks? Another 2 weeks. Okay, so another 2 weeks. Guys, please adjust your sleeping hour, sleep early, wake up early. Whoever is not staying near to UM, better depart early to prevent what we call jam, traffic jam. And also, I got a friend, same batch with me. In 2016, we sit for the CLP exam. Then he was from Puchong. Then everybody arrived at the exam hall already. Then he was rushing, you know how terrible is the traffic jam in Puchong. So unlucky, when he arrived in UN, the main entrance, he involved in a car accident. People, I think he hit some people, motorcyclists. Then, you know, as expected, he lost the mood. He don't have the patient to sit for the exam already. Then he failed that year. But the next year, he passed. So my advice is that please wake up early and arrive early to prevent traffic jam and also easy to find your car park. Okay, another student. Sir, will you share the notes in the group? Oh, sorry, I'm not sharing, but I'm selling. You can PM me if you need the notes. I will let you know the price. Okay. Anything else? If otherwise, then we will call it a day, and then we will keep in touch. If we still have time, I think maybe we can do another round because I can see many people want to do PP also. Any spotted area for this year? Spotted area, I think very hard to tell but since you asked, I think we can analyze from past year questions let me share this just a moment. Okay, so you can see this is the column to show every year what kind of chapter they ask So for court jurisdiction, I think it's pretty straightforward because like I said, the highly examinable area is magistrate court So that one you just need to remember. Triable is for magistrate is 10 years, then sentencing is 5 years. Then section court and high court nothing to memorize with because they can trial everything. Except section court cannot hear for death penalty so I think that one can spot And then arrest most every years, but not every year because you see 2020, 2021 also they never ask. Okay, but arrest and search always come together Police investigation, you see, every year they ask. But if you look into it, although they ask every year, but they like to ask the case law. So I think this is super hard to spot But I think at least you need to understand the concept Okay. So what I can share is that court jurisdiction must do arrest and search come together, although it may not appear every year. Police investigation also must know the expressly remand order expressly remand order. Although they like to ask case law, you see these two latest year. Okay. Then next one. Powers of PP. Actually, I think they ask until don't know what to ask already Nothing much they ask So my opinion again still the same. You must at least know But if you ask me whether you want to spot or not, I think maybe not that much Transfer of case also. You see, they like to ask the cases. Especially this case PP versus Adu Aziz This is about the public image, public figure If the question tell you, oh, I'm the political, oh, I'm someone who are famous, I want to transfer this case to High Court because I'm so famous, I don't want people take my photo. Then you must remember this case to say you famous is your business, nothing to do with the court. Because you are famous doesn't mean the court must transfer your case. So from the analysis, it's like they ask almost every year lah. Institution, the private summon didn't ask so much lah. So up to you guys whether you want to spot or not. Impeachment also is not that much, but again, I think it's an easy chapter you can memorize. But if you ask me whether I want to spot or not, I think maybe no lah. But again, please remember, they are very smart. They know you will spot the question, so they don't just ask one question for the entire let's say impeachment for 125 marks. They will spread into like sub 1, sub B, sub Roman 2 like that. So if you ask me, the best of course you memorize all but if you say spot, I think maybe you don't need to emphasize so much on this chapter but still you need to know okay. Then summary court and high court trial, this one usually they ask the procedure this one also I think is a must do okay. Then court for children, nothing much, you see. Actually they don't ask every year also. So if you ask me, I say instead of I say spot I would say don't need to emphasize so much next one is debt inquiry. I think you should spot, because what I can see is the most asked every year. And actually that inquiry, you can find the answer in the practice direction. Did I share the practice direction before? I think I can share one more time, but it's in Malay The court didn't issue in English Just a moment Okay, then bill also I think quite easy if you ask me, because the usually what kind of thing you ask? Number one, bill, billable and unbillable difference. Number two, whether you can appeal against the decision for bill. Then number three will be the forfeiture of the bond. These three area only. So I think you can focus Then charge. You see, charge asked every year. Especially the requirement for the charge, basic requirement for the charge. I mentioned just now. Purpose of the charge, you see. Most will ask amendment also Okay. Sentencing, because it's a big chapter, but from here analysis seems like they like to ask mitigation, okay, whipping, and also the imprisonment, whether can run concurrently or consecutively, for what I analyze okay. Then appeal, so appeal come out every year so cannot skip, okay. I don't know if I share with guys this thing or not before. Wait, I go and check. Let me share a photo then you see. Let me know if you guys cannot see the photo. So actually for appeal, make it easy Appeal regardless is from lower court to high court to court appeal to federal court. All is about the same thing. You have to do the same thing like this, which means when you got a judgment, then you need to file a notice of appeal. Notice of appeal is just a notice to say I want to appeal. Then you will ask the court who say you lose the case, ask them for the grounds of judgment to say, hey, why I lose the case, and notes of evidence. Notes of evidence is those like witness give evidence, then the court write down. Then only you can prepare your memorandum of appeal, which means the reason you want to appeal. Okay. Then all this compound, we call record appeal. Then we go for hearing. But I don't know this is for civil or criminal, but they are almost the same maybe just the name different only I can share this picture to the group also. Okay, so this is what I'm trying to say is that appeal actually is a very easy chapter. Just that you need to memorize like different date because like from lower court to high court is different timeline. High court to court appeal is different timeline Okay. Then last one is Can you guys still hear me? Can, right? Okay. So last one is miscellaneous law. So miscellaneous basically is those like not in the syllabus lah. So they like to ask lah. So something you can take note lah. Okay. So another student asked any latest cases to read up. I try to find. If I find any, then I share in the group. Because honestly speaking, I don't purposely go and find the case law one. Usually we only do the case law when they ask in the exam. Then I go and do the research lah. Otherwise, if you ask me any latest case to take note, I would say based on the trend, the past year questions, maybe you need to see those like news law, like Zaki case or Najib case, they like to ask. So perhaps you can take note of those like latest news lah. Okay, next question. Do we have to memorize the provision of DDA? I think only a few provisions you need to take note. Expressly for the bill chapter, and also I think one past year question they asked about the impeachment of the 112 statement. But I forgot which past year questions already. Just sharing with you guys. For impeachment, you cannot impeach accused for CPC offense or other offense. However, if you are charging for DDA or MACC, the prosecution can impeach you. So the DDA provision actually came out in that. I think one past year question just very latest only they ask. So to answer your question whether you need to memorize the DDA or not, I think just a few sections, not all sections, especially bill, impeachment, and also I think these two only I can recall, these two only. Okay. So shall we stop here? Can you skip court for children and appeal for court? Court for children, of course, I will still say it was better if you memorize everything lah. But if you say whether you can skip or not, honestly speaking, by looking at the analysis, it didn't come out every year. So I think if you don't have enough time, if you want to skip, reluctantly lah. And for appeal to court, appeal in federal court, I think better don't. Why? Because like I say, all the procedure is the same. Regardless is appeal from lower court to high court to court appeal or to federal court, all is the same. It's just the timeline different. And the timeline and the section different only. So I think better don't lah. Otherwise, it's quite wasted if you study lower court to high court, but then actually it's the same logic. I think better don't lah. But if you really want to ask me, I refer to here. Okay lah, if you really want to zoom in, what I can advise you is you can focus on. It's just a suggestion. You guys don't go what. Okay, for lower court to high court, a ways they will ask is that what does it mean dispose of right? Male bin su. What is that? Because in order for you to appeal, you must make sure it is final dispose of your right, then only you can appeal. This is what they would like to ask, Male bin su. And then the second one for high court to court appeal, they always like to ask is magistrate appeal to high court, whether need the leave of court or not. Okay. And then court appeal to federal court, nothing much to ask. If you really say you want to spot, then this one you don't need to know. Okay, which means I repeat, for the appeal part, you just need to know is from lower court to high court, Male bin su, because they will focus on whether you can appeal or not, whether there's a final disposal right or not. For high court to court appeal, they will only focus for magistrate appeal up to high court, court appeal, because for magistrate to court appeal, you need leave for court and it's only question of law. But then there is two case law you need to take note, which is the Pasupati and Mahadi Muhammad. These two cases, if you just want to spot, okay. Which means court appeal to federal court actually nothing much to ask if you say you really want to skip okay. Anything else? So if no, I think I will call it a day. Then wish you guys all the best. If we got chance to meet again, then we meet again. Okay. Thank you guys. Bye bye.